This is the Hidden Killers Podcast with Tony Bruschi and continuing coverage of the case against Bryan Kohberger.
When I was in your shoes, where I had a young associate handling a witness who the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that they are comfortable. You want to make sure they're treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach, if it's specific to that. If it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it, they'll get it. Just let them do their job. I'm assuming that there is, based on our prior motions, agreement. I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
I think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement. I think that may have even been in writing.
Yeah. I'm sorry, I didn't mean to interrupt. I just had that thought and I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? You have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to get an admonishment, acknowledgement from witnesses as they appear.
Bailiff, would you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not I'm not wed to the exact wording, so if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness
Only a phase 2, yeah.
and they attend phase 1, is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
Your Honor, I think that would support the need for them to be able to know it if the state's going to rely on things that
Are you talking about experts?
experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts, and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that. All right. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine off otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? I'm going to, while we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me. I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony, objection, overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word, and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advance and possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
Correct. No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were going to ask the clerk. I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name, while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, you may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome.
Yes, sir.
If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is do you want to cross-examine about the information they just presented now, or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable.
Yes, sir.
Because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them, and then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
No, sir.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So, for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that, so I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you've submitted those to the defense to review?
Yes.
And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing. The process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use Exhibit 6. Witness is on the stand, and just say, Your Honor, I'd like to go over Exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, Exhibit 6 is admitted, and then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right, so that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, Exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S-number for its exhibits, and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, so I like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab, with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever, and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury, and so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, we'll probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted, I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio, and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes or something like that when you have 30 minutes left, so you know. Just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay. Well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record, if for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together, so take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think that does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-proof, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, you know, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, you know, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase and there is a finding of aggravating circumstances, where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but
Daily versus real time?
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
And may I make that decision?
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know, particularly about the real time in advance, so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at, with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior to
It'll be part of the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss, and so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors, so we'll do that in the closed session. But anything else in the public session we need to talk about?
I believe so, Your Honor. Thank you.
No, Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
If there's a spare that we could have, Your Honor, that.
Sure.
Oh, okay. It's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I'm going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records, all right? All right. Anything else? All right, thank you.
Want to listen ad-free? Want advanced access to all of our interviews before anyone else?
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
You get every episode commercial-free.
So you can binge on true crime
until you can binge no more.
Search True Crime Today Premium Plus on Apple Podcasts now, or go to our podcast page and sign up now.
More of the Hidden Killers podcast next.